courts are basic. What do you mean by basic feature? Basic feature is where the Constitution cannot survive without these amendments, without these features, essential elements of the Constitution. The questions that were asked by the courts when they were dealing with this basic feature doctrine, which I will come to just a little later, is this, as to whether the Constitution can survive without these provisions or not. So what happened after the Keshwananda Bharati? Keshwananda Bharati's judgment came sometime in 1973. In the meanwhile, elections were conducted to the parliament in 1973, 1972. Indira Gandhi won from Uttar Pradesh, the constituency by name Rai Bareli. She won over Raj Narayan in the elections. Raj Narayan challenged her election on the ground that there are corrupt practices that were committed by her. What are these corrupt practices? He said that she utilized her people working in the Prime Minister's office and the offices of the state of Uttar Pradesh and spent more money than was permitted in the election. The Allahabad High Court declared the election as void, set aside the election of Indira Gandhi, and she carried the matter in appeal before the Supreme Court. And it was vacation time. All of you know courts don't work in vacations, and the Supreme Court was having a vacation. In those days, only one judge was sitting in the vacation. This is Krishna Iyer, whose name you must have heard. I was just told he is one of the founding organizers of this AILU. He was sitting in the vacation court, and Indira Gandhi asked for a stay, a complete stay of the judgment of the Allahabad High Court. He passed an order of a limited stay where he said that you can participate in the proceedings in the parliament, but you will not be permitted to vote. Actually, that was the starting point for everything. He said, we're not going to now give a complete stay of the judgment. We'll just permit you to participate in the parliament. That was the order that was passed. So what did the Prime Minister do, the then Prime Minister? She wanted to retaliate, and that's how there were two amendments that were brought into the Constitution. That was 38th Amendment and 39th Amendment of the Constitution. 38th Amendment gave power to the President to declare emergency in this country, and that emergency cannot be looked into by any courts. No court can interfere with an emergency. And 39th Amendment, the election to the posts of President, Prime Minister, Vice President and Speaker are put beyond the pale of judicial review. No court can look into the elections of these four persons. So they can do whatever they want and get elected, or nobody should challenge. 39th Amendment was again challenged in a very famous case, which is now Indira Nehru Gandhi versus Raj Narayan. To start with, the lawyer community was looking at the constitution of the court. They thought that this might not come out very well. By that time, emergency also has come. Four judges who were in the minority in Keshwananda Bharati case were on the bench in Indira Nehru Gandhi in the case which was taking up the validity of 39th Amendment. What did 39th Amendment do, which I just told you? It declares that these people's election, Prime Minister's election, cannot be challenged anywhere. Number two, no court has any power to go into these election matters of these four persons. On the ground that voting rights of individuals are a basic feature of the Constitution, 4:1. Justice Bhagavati was in the minority. The other four judges held that the 13th Amendment was unconstitutional, though the election appeal was allowed. So Indira Gandhi's election was upheld. We are not concerned with that, but the 39th Amendment was declared as unconstitutional by the court. What happened after the judgment of Indira Gandhi would be making a very interesting story for you all. This is something which most of you would not be knowing, because is what was happening in the Supreme Court long time back. Chief Justice Ray was made a Chief Justice by Indira Gandhi by superseding senior judges because they were in the majority in Keshwananda Bharati. Normally, Chief Justices in Supreme Court are made Chief Justices on the basis of seniority. Chief Justice Ray suddenly constituted a bench 2 days after the judgment of Indira Gandhi. 13 judges were sitting in court. Most of them didn't know why they were sitting there. They said that the judgment of Keshwananda Bharati is going to be reviewed. After 2 days of argument, Mr. Palkiwala made arguments for about 2 days, and then Chief Justice was asked by one judge sitting there, how was this bench constituted? What was the reason for the constitution of this bench? Who asked for the constitution of this bench? Then Chief Justice Ray asked Palkiwala, you asked for a review. Palkiwala said, no, why would I ask for a review? I succeeded in the matter. Then he said, the state of Tamil Nadu filed a petition for review of the judgment of Keshwananda Bharati. And the Advocate General of Madras High Court, Tamil Nadu, who was there, he said that I didn't ask for a review. Then the Advocate General from West Bengal, he stood up and said, none of us filed an application for review. Then all of them went back. Next day morning, all the 13 judges assembled and Chief Justice Ray said, we are not going to take up the matter. So an attempt that was made to review the basic structure doctrine ended like this. But the relentless struggle of the government in trying to get supremacy did not stop. The 42nd Amendment came, and the 42nd Amendment was brought by Indira Gandhi again with a number of articles, again taking away the power of the court, saying that the Parliament would have the right to amend the Constitution. Article 368 itself was amended by bringing in subclause 4 and 5. There are a number of articles that were issued. This was on the basis of a recommendation made by a committee called the Swaran Singh Committee. Indira Gandhi lost election after the emergency, but came back again in 1979. And this 42nd Amendment was again challenged, and Palkiwala had to come back from America to argue this 42nd Amendment. One thing which would be interesting for all of you to note is the names of persons which I just mentioned about Keshwananda Bharati. Keshwananda Bharati is a monk in Kerala. He has nothing to do with this case. He just lent his name. And Palkiwala argued that case. Likewise, now comes 1982, Minerva Mills. Minerva Mills had a case where the Sikh Industries Undertaking Act was challenged and it was lying somewhere. That was taken up, and 42nd Amendment was challenged, and Palkiwala argued that matter and succeeded in the court upholding his arguments that the power of amendment that is conferred on the Parliament is not limitless. And it was held in that judgment that the limited power of amendment itself is a basic structure. If you transgress this, and if you go on amending constitutions and changing the nature of the character of the constitution, that's not permitted. I was hearing a lecture of Justice Rohington Nariman, where he spoke for the 10th Palkiwala Memorial Lecture. Justice Rohington Nariman is an extraordinary jurist. I have seen judges and judges while practicing law and being a judge. But there are only a few people who can be called as legends, and Rohington Nariman is one. He was associated with this case, Minerva Mills. He just joined the bar and he was assisting Palkiwala in this case. He was speaking in that lecture. Palkiwala, while arguing, was, it seems, giving a few examples as to why the basic structure should be a feature for the constitution constitutional amendments to be made by the Parliament. It seems he asked the court, if Parliament has the power to amend the Constitution in the manner in which it likes, and if the Parliament decides that we will bring in some ruler like a Mughal emperor or somebody and then say that we will hand over the country to that ruler, they can do it because they have the power to do it. Or they say that we'll change the entire form of the government. We are following the Westminster form. Or they'll say, if the Parliament says Article 21, which protects the right to life of individuals, it says we're doing away with this Article 21. If it is permissible, then what would happen to the citizens of this country is the question that was posed. I am